Welcome to K-Talk, the Blackletter series. I am Dan O'Gorman. I am Associate Professor at Barry University School of Law.
And I'm Steve Maxwell, Director of Academic Achievement and Lecturer in Law at the University of Miami School of Law.
And in this episode, continue our Blackletter series, we have lesson number 10. We're continuing our discussion of consideration, and specifically the second requirement for consideration, the requirement that there be legal value. And as Steve, as you may recall, last time we talked about the requirement that to have consideration that there be a bargain for exchange, that each party manifest an intent, at least in part, to get what the other is giving. That kind of is the heart of consideration. But we've got this other little element, something called legal value, floating around, which can arise, not often, but it can arise, and so students should be aware of it. Legal value, boy, if this is one area where terms can be tricky, legal value, if I said to you, Steve, it has to have legal value. Just if you're a layperson, new to law school, and I say, well, son, this exchange has to have, quote, legal value. What are you thinking? Do you have any idea what I'm talking about?
Probably not. I think if I am trying to delete the last 10 years of my life is a challenge, but
do you want to delete the last? No, I'm just kidding.
That's a different podcast.
That is a different podcast. Maybe that'll be a spin-off podcast.
Right, exactly.
For premium members, they can
watch that, yes,
right?
Exactly.
For a little extra on the patron money. Yeah.
Absolutely. Click if you like it, ring that bell and subscribe.
Exactly.
I think what a layperson would do is just hear the word value and think something that's worth something, but not really like legal. I think is where we get thrown off.
Indeed, this adjective is going to be loaded, and I could think of, well, legal value. You mean like legal tender? The money's got to be good. It's like, wait, is Bitcoin legal value? So you're absolutely right, Steve. It's going to be the legal adjective, which is going to cause some issues here. It's definitely legal here is definitely going to be a legal term of art, to be sure. So here's my thoughts on the legal value requirement. This legal value requirement in today's day and age with consideration is doing very little work. It doesn't come up that much. All legal value means, and remember what we've already got. We have an exchange. Let's just do a typical maybe bilateral contract where it is an exchange of a promise for a promise. Now we know to decide whether or not that exchange of a promise for a promise, that transaction has consideration. We know each party in a bilateral contract has to be committed to something. And of course, if they're each giving promises, they are committing to something. Each has to do something. It's not a promise of a gift just one way. We also know that for it to be a bargain for exchange, a reasonable person has to believe that each party was motivated, at least in part, to make their promise to get what the other is giving. So the promisor is making the promise to induce the promisee to make their promise, and we believe that the promisee is being induced to make their promise to get what the other side is giving, so-called reciprocal inducement. And we know we don't care if there's an inadequacy in what's being exchanged, at least in terms of deciding consideration. As we know, even a peppercorn can be sufficient. And that's our bargain for exchange requirement. That really is, if you think about it, that's sort of the heart of a contract, is that you've got a bargain. That describes a bargain. There's an exchange, promise for a promise, and it is being bargained for in the sense that each party seems to be entering into this transaction to get what the other is giving. That's what makes it a bargain for exchange. And we know you don't have to actively bargain. We talked about that last time. It's just about whether we believe each party is motivated to get what the other is giving. You'd think you'd be done at that point. When you see like, hey, a contract's a bargain, what more could there be after that?
I think the more comes from mean contracts professors wanting to throw a little curveball at one else. That's where that comes from, because 99 times out of 100, it's the money for the car. It's the money for the painting of the home. It's this for that. And and generally we don't get here to talking about legal value almost all the time. So how do they know when they're being tested on this?
And let me just point out, you're very right. You talk about the mean contracts professors. When I talk about unilateral contracts in class, I say, well, in the real world, there's not that many unilateral contracts. There are offers of rewards, there are offers of a prize. You may have some others here and there. But, probably, I don't know. I haven't done research on this, but I'm thinking, more than 99% of the contracts are bilateral, probably. But I say, yeah, well, they might be rare out there. I point out the window. But in here, in a contrast, they're way more common, right? On a law school exam and law school, we love unilateral contracts,
Right. They're popular because they take a bit of care to spot the issue, and they take a lot of preparation to be ready to handle the analysis of that issue. And that's, I think, why they're so popular to professors. It's easier for a professor to separate the book award from a B on an issue like this, in my opinion.
Well, Steve, I'm so mean. That the B and the book award are the same thing in my class. No, I'm kidding.
It's the hardest C+ you'll ever earn.
That's what you said. Don't scare my students. They're still watching this. The B, no, it's an A. So what is legal value? So the way I like to think of the legal value requirement is that even though the parties have entered into a bargain for exchange, and in 99+% of the cases in the real world, we are done. You can just basically say, yeah, we've got a contract, we have consideration. There are some situations in which the law decides that even though there is a bargain for exchange, that bargain for exchange should not be legally enforced, which shouldn't be consideration. And I'm not talking about things like where there's a misrepresentation necessarily, or duress, those defenses, those excuses, statute of frauds issues. I'm talking about just there's certain situations where we're actually going to say there's no consideration, even though there's a bargain for exchange. Not that a contract is formed and say it is voidable, which is a topic we'll talk about with defense and excuses, but we're actually going to say you haven't quite made it to having consideration for policy reasons. It sort of reminds you of when, something is a little green line is saying 34%, 54%, and it's rolling and you're feeling good. And you hit 99 or 98 and it stalls. And you're getting very nervous because you're feeling like maybe not really 98% there. This is sort of like legal value. You get that bargain for exchange, you hit the 98 and it stalls. And we're going to make sure that you can get over the hurdle and get to the end. So let's first talk about what is legal value, because I know I've made it sound really scary. Like, oh my gosh, this legal value requirement is horrible. Oh my God, we're going to stall at 98. Okay. Most of the time, no worries. Your bargain for exchange is going to have legal value in the vast majority of cases. All legal value means is that each party, with what they are promising to do or doing, because remember, you got to have an exchange. What they are promising to do or they are doing involves them waiving a legal right that they had. Now, we could quibble with this definition, but let's not, because this definition I found, I didn't use this definition for a long time, Steve. When I taught you, I don't think I ever phrased it this way, but I haven't found a phrase that is, I think, just easier for students to understand this concept than this one, waiving a legal right. Here's how it works. It's this simple, Steve, this simple. What are you promising to do for me, Steve? So let's give me a bargain for exchange.
I promise to give up smoking and drinking.
Oh, you're going there, aren't you? You're going to make it a little, it just couldn't be a sale of a bike.
No,
you had to go to Hamer versus Sidway.
Well, okay.
No, this is good. No, this is perfect. No, I tease. You are right. Because you can't give up the 10 years, can you? You can't give up, you can't go, and you never go home. So you can't go once you study Hamer v. Sidway, you can't go back.
That's right.
So Steve, of course, is bringing up the facts of a very famous case. Hamer, I like to pronounce it Hamer. I don't see two M's there. I say Hamer. versus Sidway, where yes, Steve has promised to give up with smoking and drinking.
Yep.
And I assume you mean alcohol.
Yeah, it couldn't be water. I wouldn't make it to the legal value that I want.
Yes, not yes. You're not going to ever be alive to see performance. So Steve has promised to give up smoking and give up drinking alcohol. And in exchange, I assume I'm going to promise to pay you maybe something like $2,000.
That sounds great.
Sounds great. So we've each given a promise. This is a bilateral contract. We've each given a promise. So the question first is, of course, is there a bargain for exchange? Would a reasonable person, each person is motivated to get what the other is giving? And let's assume we get past that. Let's assume, Steve, that you are, I don't know. How about my nephew?
I don't know. I mean, isn't former student, fun colleague good enough?
Yes, perhaps we certainly don't want to go down the road of, is this actually a gratuitous promise subject to a condition? So I'm going to try to stack the facts here, make it sufficiently clear that a reasonable person would believe I'm motivated to get what you are giving, your forbearance. I'm not just giving you a gift, though I guess in a certain way, if it's the family member, maybe it actually pushes stronger in favor of gift than I'm just giving you but I also was thinking about, hey, I'm trying to protect my name and my reputation. But let's assume for whatever reason.
This is what law school does to you, is you start overthinking everything, but it's great. That's the cool part about this, is that you just have to spot the issue, make the arguments, and conclude. And what your professor, for goodness sake, just thought of a counter argument to his argument.
You can't, the problem is it's so hard not to digress when you're talking about hypotheticals like this. And that's what happens. You see these little trails off on the road, like, wait a second, is this really a bargain for exchange? But of course, we're talking about legal value today. So let's assume that a reasonable person would believe that each one of us, and particularly me, is motivated to make their promise to induce the other party to give what they're giving. And as we know, a forbearance can be consideration. A promise to forbear, the promise is the consideration. It doesn't matter that it's a promise to forbear. So
right.
now,
And I have a legal right to smoke and drink, right? I mean, I'm over 18 and 21, and that means that I'm waiving a legal right. Am I right?
you are correct. So here's where we get to the legal value requirement. So assuming each party is bargaining for what the other is giving, the second requirement of consideration, and it is an and, meaning it's elements. You need both of these, not one or the other. The next requirement is that each party must be either promising to waive a legal right, that which they are promising would involve them waiving a legal right, or they're actually waiving a legal right. For example, a unilateral contract, you would just waive it, you just do it, or maybe you're releasing a claim immediately. So yes, so the way we would analyze this for legal right, element number 2, and remember, we're asking, does Steve's promise have legal value? And does my promise have legal value? And you need legal value for both of them in order for consideration to exist. And Steve, you are absolutely correct. As you just mentioned, your promise to not drink alcohol and to not smoke does have legal value because you have a legal right to engage in those activities. And you are promising to forego, to essentially waive, to give up that legal right to do that. And it's a little bit easier on my end because obviously I have the right to my $2,000. I am promising to transfer ownership of $2,000 from me to you. So I'm waiving the legal right to not simply give you the money. I'm waiving my legal right to ownership of the money. It is, most of the time, it is that simple. Let me tell you where students struggle. And I'm glad that you brought up Hamer v. Sidway, because I use that case to help students understand where they can go awry with this. There is a difference between legal value and actual value. And this is what ties students up in knots. And I can stand there, Steve, and tell my class again and again, and have it on the PowerPoint in big letters, legal value is not the same as actual value. And I will, and I understand there's so many rules, there's so much to learn, it's hard to keep it all together, that on the exam, I'll have students, they will fall off the wagon, no pun intended with your hypo, they will fall off the wagon and they will launch into a discussion of legal value and start talking about it as actual value. And you know where this, I think a big culprit is too? Something called the legal benefit, legal detriment test. So traditionally, consideration has been identified. The language is, the sort of the old Blackletter language was, there is consideration provided as long as there is a legal benefit to the promisor or a detriment to the promisee. Each side, right? So for the promisor to be getting consideration, they must receive a benefit from the transaction, or the other side, they must induce a detriment, and vice versa. And if you got it going both ways, you got consideration. Well, here's the problem. When you hear benefit and detriment, you think actual benefit, actual detriment. And even if you add legal on there as an adjective, legal benefit, legal detriment, you still see benefit or detriment, and you're taking that seriously. You're thinking, oh, I must investigate whether or not there is actually a benefit or a detriment, right? A benefit to this side, or the inducing a detriment, and then do it on the other way. And let me show you how this is going to cause problems. And it did for the lower court in Hamer versus Sidway, where Uncle William promises nephew Willie this money if he doesn't engage in these activities. So the lower court says, is there consideration for this transaction? And the big question, of course, is whether or not Uncle William is getting consideration. We know Willie's getting consideration. He's getting the money. The question is William getting consideration? Uncle William, because you have to have consideration go both ways. And the court looked at, the lower court, looked at it and said, well, you know, is Uncle William benefiting from this transaction? And they said, you know, we're not sure Uncle William is. What is, you know, it's like, Steve, if you don't smoke and you don't drink, what do I really get from that? I mean, what does that do for me, Steve?
Right. If it's just benefit, actual benefit, there's really nothing. You are not bettered by it, except maybe the feeling that your nephew is refraining from these activities that you judge as harmful.
Exactly. And the lower court was viewing benefit in more hard benefit, monetary type terms, talking about things like, where's the monetary benefit for this? And so this sort of warm and fuzzy benefit was not doing it for the lower court. They were looking for much more benefit in terms of like a monetary benefit, and they're not seeing it. Then they say, well, wait a second, it's a benefit to the promisor. Well, we're not seeing it, or a detriment to the promisee. And they say, well, you know, is this really a detriment? So Steve, when you stop smoking and stop drinking, is this good for you or is this bad for you?
Oh, yeah. Yeah, that could be a strong argument that that's good for me.
Exactly right. And the lower court believed this was actually a benefit. Yeah, Willie would be better off. So no consideration, because there's no consideration being provided to Uncle William. He's neither benefiting nor is he inducing a detriment. He, in fact, is inducing a benefit as a result of this. It goes to the New York Court of Appeals, which many students would probably know is the highest court in New York. I remember, I think the New York Supreme Court is the lowest court. I remember a friend of mine once told me that before he went to law school, I think he received, you know, jury duty at the New York Supreme Court. He's like, woohoo, I'm going to high school to land.
It's kind of like legal value versus actual value.
Exactly. He's like, what is this? What? You know, it didn't cross his mind that you're not going to have a jury at an appeal. But I mean, he wasn't a law student yet, so he didn't know, right? Or does he know?
Right.
So this comes to the New York Court of Appeals, and the New York Court of Appeals is like, stop. You've got this all wrong. Legal value just means a legal benefit to the promisor. If you're asking if the promisor has gotten consideration in exchange for the promise, is this transaction providing them is the other party's performance providing them anything of legal value, or is the other side, by making their promise or they're performing their act, are they suffering a legal detriment? And right to where we started at the beginning, the importance of that word legal, the adjective legal. This, Steve, is going to just basically pop the balloon. It is just going to deflate a lot of the oomph in this doctrine, because as we talked about, legal value, including legal benefit, legal detriment, just means that the other party is waiving a legal right. You do not ask whether or not the waiver of that legal right was provided some actual benefit to the other side, or was an actual detriment to the party that's waiving legal right. You ask one simple question: are they waiving a legal right? If they are waiving a legal right as part of this transaction, then we would say that they are both suffering a legal detriment. So it's a legal detriment, Steve, right? Because you may be better off for not smoking and drinking, but wouldn't you view that as at least a quote legal detriment?
Yeah, absolutely. Because if I have the right to do it and I'm saying I'm taking that right away from myself, then I don't have the option to do it anymore if this is legally binding.
You have less freedom.
Right, exactly. And that's big in the news today, right? I'm getting rid of my right to drink or smoke or whatever it is. Now, let me ask you this. Maybe this is a tricky, maybe we don't even want to go here. What if the nephew is 16 and cannot legally drink or smoke?
So this is an issue that the restatement, I've looked at this, and my conclusion, if other law professors or students want to point me somewhere that I've missed, is quiet on this issue. And here's where it gets complicated. Really what you're asking is, what happens when the party is waiving a legal right, but the right they are waiving is of a duty that is owed to, so they don't have a legal right, but the right is held to by somebody else. So in other words, you have a right to not smoke. I'm sorry, you have a duty to not smoke. And so this really should bring in the next line, which is our pre-existing duty rule, right? Because let's float into that now. So this is a good segue to that next topic, which is, okay, tell me when there isn't legal value. And we know there isn't legal value then when you are not waiving a legal right. What you are doing or promising to do is something you are already under a legal obligation to do. Now, in most of our contrast cases, this is going to involve a situation where the parties are seeking to modify or alter an existing contract, and we'll talk about that. You've raised an issue of, what if I am underage, and so I'm under a legal duty to not drink? So let's just do that one. You're 16, and you promise your uncle that you're not going to drink alcohol, which is illegal. The question is there still legal value here? And it gets complicated for the following reasons. There was a big split, and there remains a split of opinion among courts as to whether or not there is legal value when a person is promising to not do something that they did not have a legal right to do, but they owe that duty to somebody else. So when you're 16 and you promise not to drink, and we know you have a duty not to drink. The problem is, and the reason why it gets complicated, is that do you owe me a duty not to drink? Who do you owe the duty to?
Right, the state.
And then it becomes more complicated. So am I part of the state? I mean, I can't prosecute you, not me. The state will on my behalf. And sometimes where this definitely happens more is when you might be under an existing contract with a third party and you promise to perform your contract with the third party. And so you have, it's similar to the state issue. You have a duty to this third party to perform X, and then you go to somebody else and you say, hey, you know what? I promise to perform my legal duty that I owe to the state, that I owe to this third party under the separate contract. I promise you that I'm going to comply with that duty that I owe to this third party. And the other side presumably has some interest in you performing the duty that you had to the third party. And they're like, deal, I'll pay you extra money if you promise to perform your duty that you owe to this third party. Now, the restatement says as follows. So this is split. So, your professor may be teaching this as some jurisdictions say this and some say that. So check with your professor. If you're in practice, check your jurisdiction, bar exam, check what your bar exam is expecting you to say. The restatement says that you are only considered to have a pre-existing duty. And therefore, what you are promising or doing doesn't have consideration if the duty is owed to the other party to this contract. So let's do the more simple case before we get to a more complicated case. The simple case under the restatement is if you have a contract with a third party to ride in a race. There's a famous case dealing with a jockey. Let's say you're a jockey and you're under contract with the owner of the horse to ride in the race. And let's say, and I'm going to change the facts a little bit to make it a little bit simpler. You then come to me and you say, hey, look, just to let you know, I'm thinking about breaking my contract with the owner. I'm not really feeling like riding. And I promise you $500 if you do ride. So what's happened now is you promised me to perform the duty you owe to the third party. And in a certain respect, you are under a pre-existing legal duty. You want to think it doesn't have consideration. But what the restatement says is that my promise to you is supported by consideration. Your promise to ride in the race is not run afoul of the pre-existing legal duty rule because your duty was not owed to me. You're not re-promising me a legal duty that you owe to me. You are promising to do something that somebody else, like I had no right. I mean, I had no right to compel you, and you are promising to perform a duty owed to a third party. The restatement will say that there is consideration for this.
And that sort of seems to purport with our economic system and law and economics, that if I was in a bad deal over there and I can get a better deal over here, we want to endorse that. We want to rubber stamp that. So in a way, I think that's sort of like an efficient breach type of rule.
And I'm glad that you brought up sort of this law and economics stuff. I'm not going to go too heavy into law and economics, but it sort of brings up the question of why do we have the pre-existing duty rule? If you're going to get into these little questions like, well, should the duty be owed to the other party, or should there not be consideration if it's owed to the third party? It's really strange, isn't it, trying to answer that question without asking, well, why do we have a pre-existing duty rule? I mean, it all gets sort of very logic-based and artificial.
Yeah, if you know why it exists, it's easier to remember the rule itself.
Exactly right. And okay, so I'm going to give you the restatement rule, what some other courts will do, and then I'm going to mention to you why we believe sometimes we have to say that. The common law comes to us through the mists of, a lot of this is lost to the mists of time. It's not always so clear. Like, I don't know, because, records of old English opinions aren't always so clear. A lot of this stuff is kind of like, well, why do we do this? I don't know. My dad did it. Well, why did he do it? Well, his mom did it. Why that? And you never know. So the restatement says that if in order for the pre-existing duty rule to preclude the promise from being consideration, the duty must be owed to the other party. So in other words, in the jockey case, it says there's consideration here because the jockey was promising to perform a duty, yes, a pre-existing duty, but it wasn't a duty owed to the other party. And so there is consideration. There are going to be jurisdictions out there which are probably, in fact, there is a Florida case which would support the argument that we here in Florida follow the older rule. It was a case where a guy was a polygraph examiner and he tries to claim a reward because he's doing a polygraph exam for his employer. And he figures out the guy did, he's like an independent contractor. He's brought in to do the polygraph exam. He's under contract. And he figures out that the guy did this crime. And then he tries to claim the reward. The reward was being offered by somebody else. The reward wasn't being offered by his employer. So under the restatement, he should be able to get it because he didn't owe a duty to the person offering the reward to do the polygraph exam and get this information. But there are jurisdictions which will say, no. It's more simple. You just ask, is the person under pre-existing legal duty? If they are, there's no consideration. We don't ask who that duty is owed to. Now, back to your question. I'm 16. My guess is most contracts professors are going to, I'm just speculating. I mean, I should have like a disclaimer. We need like a disclaimer. I'm not good enough at YouTube stuff, Steve, to have like disclaimer with a big explanation point come up there. So I'm just speculating now. I don't know what's going on in other people's classes. My guess is most contracts professors, most bar examiners, most bar graders, most people are going to probably say that a promise to not commit a crime does not have consideration, and they're not going to think a lot about, is that a promise owed to a third party, the government, or is it not? Is it third party? Is it not? Is everyone part of the state? Or, they're not going to probably think along those lines. I found the restatement to be, it's really did not provide much of an answer on that. They talk a little bit in the comments. I think the restatement says there is consideration, not clearly, but the restatement talks about this and seems to direct us off to a public policy analysis. Is this contract against public policy? The fact that the restatement comments seem to be sending us down to the public policy room sounds like they're saying you're okay in this room, the legal value room. But I think a lot of contracts professors would raise their eyebrows if I said that. And so check with your professor. You may actually want to ask that. Hey, professor, what's your position on a promise to commit promise to not commit a crime? Is there consideration, or is that the duty is only owed to the government, and so there is consideration? Because if you think about it, now let's talk about, before we think about it, the purpose of the rule, which is what you were heading in that direction with talking about law and economics. What we think is what their statement thinks, that this rule was designed, the pre-existing duty rule is a rule that is intended to prevent parties from coercing other parties. So I have a duty that I owe to you, Steve. I already owe the duty to you. And I come to you and I basically say, look, I'm not going to perform my duty that I owe to you unless you pay me more money. And I extract from you extra money to perform my duty that I already owe. Even if I may come with you with good motives, Steve, and you have an amazing memory. That's why I say you may remember this case, even though it's been 10 or whatever years ago, or more than that. I'm sorry, no, it's been like 14 or something.
Yeah, I guess so. Jeez.
I don't know. Yeah, I'm sorry. I mean it. So I say to you, I don't remember Levine versus Blumenthal, which was this case. It was a squib case where this woman is running into trouble paying her rent. She has a little shop where she sells clothes, and the depression hits, I think, and she's having trouble paying her rent. And she asks for a discount on the rent. And the landlord says, yes, because she threatens to breach, but she has good motives. She doesn't want to breach. It's not the holdup game that we'd say. She's not trying to coerce anything from him. She's saying, look, I'm not making enough money. I have no choice but to close my shop and leave. And I'm not going to pay any rent then unless you reduce the rent. I'm not trying to threaten you. Don't take this the wrong way. I'm just keeping it real. And the landlord says, you got it. And then he turns around later and sues her for the excess rent. And the question is whether the rent she didn't pay. And the question is whether or not there was consideration for their agreement to modify the contract with the lower rent. And the court says there wasn't, because she was under a legal duty to pay to him to pay the greater rent. So when she repromised to pay lesser, she was just repromising to do, there was no consideration for his agreement to forego that extra rent, because she was simply promising to pay an amount she already had an obligation to pay. But we think that the legal duty was probably based upon a concern, not of that, but as you may recall, I know you're going to know this one, right? Domenico versus Alaska Packers.
Right. The fishing case where they're trying to hold up the shipping company, or the fishing company for higher wages right at the last minute once they're out at sea and the ship has sailed.
Exactly. The ship is sailing. Even worse than that, they've arrived at port in Alaska. They're not going to be able to find replacement workers. They go on strike, and the company really has no choice but to pay them the extra money to give into their demands. And let's assume that the fishermen are acting in bad faith. They're trying to coerce more money, not because anything's changed, but simply because they know they now have Alaska Packers over a barrel, so to speak. And there's some issue about where the net's bad, but let's just, for our purposes, let's assume that they're just trying to coerce the so-called holdup game. I know I've got you. The gun is, I have you between a rock and a hard place because I've got a gun at you, and now I've pulled out the gun, and now you have a choice. Look, you have a choice. I always tell my students, when you hand over your purse or your wallet to the person that's holding out the gun, is your action voluntary? And they're all like, no. I'm like, are you kidding me? That is so voluntary. That's like, you don't get more voluntary than that. You're like, you so much want to hand over your wallet. The problem is the choices are they going to shoot me or give my wallet? I very much want to hand over my wallet. So Alaska Packers is viewed as the reason why we have a pre-existing duty rule, which is we're concerned about people playing the hold-up game. We're not supposed to, it's really not designed for the Ann Blumenthals of this world to come in good faith. But the problem is, it is written as a rule. It's not a standard. It doesn't ask, was there coercion? It's a rule. It's very prophylactic if you think about it. We're going to have a broad rule. And if we capture some cases, some Ann Blumenthals in here, well, that's too bad. But that's the bad news of a rule as opposed to a standard, which brings us back to your question, which is the 16-year-old. I guess the question is, there's really not sort of the coercion that we would be concerned about. With a 16-year-old saying he's thinking about drinking, he's not really coming and coercing, because there's no pre-existing duty to me. It's not like you're coercing me, like I've got a right to have you not drink, and you're coming now and trying to get more from me after I already have an entitlement from you. I'm really just sort of giving you an added incentive to do something that you owe to somebody else. So I personally think that the restatement gets it. I think not only did the restatement get it right on third-party business, I think it makes sense to say that there should be consideration for the 16-year-old promising not to. I mean, we can make it more eerie. The person says, unless you pay me more money, I'm going to, commit some more horrible crime. I don't know that there's maybe not. You could say there's consideration there. Don't panic. Don't freak out. We have other doctrines like public policy that can come in and say, well, we're not going to enforce. Are you kidding me? we're not going to force a contract with a kidnapper, for example.
Right. And I think that's really confusing for a student, but it should be a bit of a relief that you can actually argue these facts a couple of times in your essay if you're writing it, because one, you'd want to challenge the consideration. And I think you'd get a lot of credit just for spotting it as a potential consideration question. But then it clearly comes square in on another defense later in your essay. And don't worry about that. It's just one of those things that happens. This is why all these legal doctrines are out there, is to stop these weird situations from getting out of control. So I think that's a really, really good point, that and for students to keep things straight, be looking for this question, this legal duty, this pre-existing duty rule. Look for it. You don't have to be the best. You don't have to know the right answer, because I mean, the courts disagree, the professors disagree, the restatement disagrees with all these other authorities. So, just keep things separate and know where to argue them. I think that's the name of the game here.
I think it would probably be comforting for students to know that when contracts professors, and I assume this is in all areas of law, they get together and they disagree. It's not like we all get together and we all really have nothing to talk about because we all agree on the same answer. We can get together and we can disagree. And so it isn't always so cut and dry. And I think you're right. That should be, hopefully, is somewhat comforting to students. And just to know, keep these issues contained. I mean, where things get troubling is if you're talking about the pre-existing duty rule and then maybe you start floating into a public policy analysis where it really doesn't belong. You want to sort of understand, what is this doctrine? Keep it contained. If I'm going to do a public policy argument, keep that separate when we talk about defenses and excuses. But this is, so the most of the time, this doctrine comes up in the modification of a contract. So the parties have a contract, and one party wants they want to change. They want a modification, and they ask for modification, and the other side consents. We know the other side never has to consent to a modification unless parties' duties have been discharged, but that's down the road. A modification is bilateral. The party, unless the contract provides it, does not have the unilateral right to modify the contract. So I come to you, will you give me more money for fishing? I'm Blumenthal, will you give me more money? And the other side agrees to modify, to give more money, to reduce the rent, to whatever. The problem arises when it's all one way. Both parties have agreed, but only one side is getting anything. So in Alaska Packers, the fishermen are getting more money, but they're not giving up anything. I mean, they're just promising to to fish again. I mean, they're already under duty to fish. So they're not promising you anything more than they already had a duty to do. And Blumenthal, she's getting everything. She's getting the discount on the rent, but the landlord is simply getting her to stay and continue paying rent, which he already had a legal right to get. So he's not getting anything new. And what we say, and Steve, I know you're hear this rule. My guess is you're like, oh yeah, this is a bar exam line. This is a keeper, which is that to have an effect, in general, to have an effective modification of a contract, you need new and independent consideration.
Yeah. And I think of that, the way I think about that is some change in performance. Just any real change in, like if Ann Blumenthal were to pay the reduced rent one day early, I think that would be, oh, well, now she has to perform her duty a day earlier. Then that should do it. Am I right?
You are. The vast majority of the time that is going to do it. And we know that's going to do it because, so the common law views a modification of a contract as forming its own contract. Essentially, the modification itself has to satisfy the requirements of contract formation, its own little modified contract being formed. And so we know with consideration, assuming a party like Ann Blumenthal is promising to pay a day early, we now know that part of what she's giving, she was not under a pre-existing duty to do. And we also know, of course, under our so-called peppercorn theory of consideration, courts generally do not assess the adequacy of that which is being exchanged. So the fact that she's not giving a lot, just one day early, as a general matter, almost all the time, is sufficient to make this consideration and to make the modification legally binding. The only little wrinkle, probably one most students are not going to talk about a lot in class with respect to modification, is, if it's really, really small, it could be sham. We talked about sham previously. If the parties are simply putting it in there to make it look like there's consideration. But I think most people believe that when you're talking about a modification, sham is typically like, I want to give a gift to my niece, and so give me the dollar. It's sort of reasons to believe why the parties would want to make this look like a bargain to make it legally binding. But typically your modification of a contract, people aren't typically throwing in stuff to make it legally binding. I mean, it's interesting. If Anne Blumenthal is wise to this, she's seen this podcast, maybe she's smart. So, hey, please let me pay it. The least I can do is pay it a day early, right? Let me do that. She's kind of like throwing the peppercorn at the other side to make it binding. She's like, no, I don't really need the peppercorn. No, take it here, please. I beg you, take the peppercorn. So, sans that, yes, if we believe that each party is motivated to get what the other is giving, even if it's very small, like a day, or he's like, oh yeah, that'd be great. I'll give you the rent. Certainly, if he says something like, I'll do that, but you need to pay me a day early. Oh, now we're talking consideration for sure.
Yeah.
Manifested a motive to get it. All right, let's talk. Boy, courts, you know what? State courts hate the pre-existing duty rule. It's mean. Think of Anne Blumenthal. It's mean, isn't it? It's horrible rule.
It is, but it's also clear, which is the flip side of it. It's a lot easier when it's clear, but of course it does tug at some heartstrings, especially, I mean, Anne Blumenthal, Exhibit A.
What is that old saying? You can take the econ professor out of the econ class, but you can't take the econ class out of the econ professor. Steve, you're such an econ guy,
I live and breathe it. It's great.
It is. I like how you immediately gave the counter argument for having a rule. This is always the problem, is that if it's a rule, it's the good news is it's clear, easy to administer. It's the land of multiple choice questions usually, right?
Yeah, and we don't even, and it's good for a court. Doesn't even have to delve into the motivations or anything like that. It's expedient.
It absolutely is. But of course, the downside is then you do have some injustice every now and then. We scoop up the Anne Blumenthals of this world, and we probably don't want it. I mean, that wasn't the purpose of the rule. If the purpose of the rule is preventing coercion, Anne Blumenthal is not coercing. She's like, what am I doing here? And I'm like, sorry, it's a rule. It's like, I can't help you. So, but courts have been concerned about people like Anne. I'm not saying Anne Blumenthal is going to survive this. But just the mere fact that this rule does seem to lead to injustice in a lot of cases has led to exceptions. And I like to phrase it as ways to circumvent the pre-existing duty rule. And honestly, Steve, in a lot of ways, learning the pre-existing duty rule, a lot of it is just as important as knowing the exceptions. And now, of course, that's not unusual in law school or the bar exam. Is that right?
No, it's certainly not exceptional, if I can make a pun.
It is not exceptional to have to know the exception. Exactly right. And thank you for pointing out that was a pun, because I do sometimes, make everything literally. That's just
exactly. That's why I have so much fun with it. But I'm trying to be nice.
I appreciate that. Oh, so you like it when I miss it? I just keep talking on you. Like, oh yeah. Oh, Gorman so didn't get that. That dude is so clueless.
I knew there's gonna be 3 or 4 students that are gonna hear it and go, he didn't get it.
He didn't. Oh, that's like the very first episode. I think I can't remember. You said something about contract right off the bat as a pun. Yeah, right over my head. Okay. Ways to circumvent the pre-existing duty rule. Look, the pre-existing duty rule is about consideration, is it not? It's legal value issue. So, all the pre-existing duty rule means is that there wasn't consideration for the modification, which we know as a general matter. We treat a promise to modify a contract basically like any other promise. The general rule is you got to have consideration. A little bit, one professor, Jack Dawson, I think it was, who said something effective. These are examples with using consideration everywhere Like, oh, you have an option contract. Well, you have consideration for the promise to keep it open. Hey, I got a promise to modify it. Well, do you have consideration for a promise to modify? Consideration walking around and harassing every promise and being like the test of enforceability. I think Professor Dawson called that this doctrinal overload. Like, you're having consideration do work in like everywhere. Like, really, guy? I mean, every promise you find, you're like all over it, harassing him, and you're the test. And courts have felt like it is a bit of doctrinal overload. But here's the good news. Even if it isn't doctrinal overload, we know that an alternative way to make a promise legally binding is well, he's not that old. He's actually kind of a new friend. I don't know why I said old friend. Our new friend, like, I don't know, 100 years ago, our new friend, promissory estoppel. A promise that is reasonably foreseeable to the promisor, that it will induce detrimental reliance by the promisee. It does, in fact, induce detrimental reliance by the promisee, and injustice would occur if the promise is not enforced. If I promise to modify a contract with you, Steve, you come to me and you say, hey, O'Gorman, this contract, I'm having trouble, blah, blah, blah. Will you modify it? And it's a one-way modification. I mean, I know modification requires mutual assent, but it's all you. I ain't getting anything out of this. You're just staying. So I'm not getting any consideration. I'm just being a nice guy agreeing to modify it. No consideration. General rules is not legally binding. But you then detrimentally rely on the promise. If the elements of promissory estoppel can be satisfied, that promise to modify is legally binding, irrespective of the pre-existing duty rule, because pre-existing duty rule is solely about, is there consideration or not? So, famous case, I think it's Freed versus Fisher. You're a partner in a florist shop and you want out. You're jointly and severally liable with your other partner on the rent. And you come to me and you say, look, O'Gorman, I'm the landlord. I want out. I want to pursue my dream. You may have been, I think, yeah, you were in a florist shop and you're going to open, you may have been in a restaurant and wanted to open a florist shop, or vice versa. I like the dream of a florist shop. Sounds funny, right? I don't know why it's funny. I didn't mean to insult any florists here. You say, O'Gorman, I really want to open a florist shop, but I gotta get out from underneath this obligation here to do that. And I'm like, don't worry, Steve, pursue your dream. And you do. And then your partner defaults. And I turn around and sue you. And you're like, wait. You let me go. You promised to modify, let me go. And I say, yeah, but what did I get out of that? Legal duty rule. You gave me nothing. There would be no consideration for that modification, but you detrimentally rely. And I knew you were going to detrimentally rely. I knew you were going to go over to a florist shop. You went, and presumably now it would be an injustice to now hold you to that when you would have stayed in the restaurant business and made it a success. I assume the other guy ran it to the ground, and now you're struggling to get your florist shop because it's new, and you wouldn't have been in this predicament if I had not told you you could be.
So what if Anne Blumenthal goes to the landlord and says, hey, look, I don't have enough money to feed my family, and I need the $100 off the rent so I can buy groceries. Landlord says, sure, no problem. Buy your groceries. I'll reduce it. And she goes and buys the groceries and feeds her family. Now Anne Blumenthal is saved.
That sounds to me, I like that essay. I should take notes on this. This is a good essay question. Probably yes, because she's done something she wouldn't have done. I mean, the converse sounds pretty horrible, right? Which is that, well, she would have paid the rent, and sorry, kids, you're just not eating. But that sounds like that, it lines up with yes, she detrimentally lied. She wouldn't have spent the money. She did. And now she's having to spend it twice, where she would have only spent it once because he promised. And what's great about it is this is just, look, this is no special modification rule. This is just taking a doctrine that is established, promissory estoppel. It is a way to enforce a promise, make it legally binding, and just say, look, we're going to say as a general, if you're going to treat promises to modify a contract as basically the same as other promises, then fine. but don't treat them any worse. If another promise can be enforceable because of promissory estoppel outside of the modification context, don't make it any worse and say, well, but we're not going to allow you to use promissory estoppel, with modifications because we've got this independent consideration requirement in addition to new and independent consideration to modify. So yes, that sounds like an example of where promissory estoppel would apply. Now, though, let's do a situation where you wouldn't have promissory estoppel apply. So you don't have consideration, you don't have promissory estoppel. The next question is it done? All other slides, non-modification, except for, say, option contract with that firm offer business, typically promises are being treated all across the board the same. Do you have consideration? If you don't, can you do promissory estoppel? And promissory estoppel is hard to establish. There's going to be some situations where promises are made in certain contexts where the courts believe and the drafters of Article 2 believe that these promises should be more easily made legally binding. And we should have some special rules. We've seen this with firm offers under Article 2, right? A merchant in a signed writing gets written assurance that an offer will be held open. You don't need consideration. You don't need promissory estoppel. That alone, that formality is good enough. This is another situation. Courts think that promises to modify should be treated as special, more easily enforceable. And here we're going to see a split between the common law and Article 2 of the UCC. The common law is going to be a bit tougher. It's going to have a special rule and soften things up on promises to modify, but it's not going to go as far as Article 2. And this is almost always the case. Article 2 is always more easy to keep deals together, to make promises binding. It just tends to be easier than the common law. The common law has something called the unanticipated circumstances doctrine. The unanticipated circumstances doctrine is going to deal with a situation where the modification was a result of some unanticipated circumstance happening. This is what prompted the modification. It's not the holdup game. It's not Alaska Packers. That's not an unanticipated circumstance. That's
say Alaska Packers, say it's 30, 40 degrees colder than normal. And the Alaska Packers, they have to get out there in that true frigid cold and they want more money. Different scenario? Perfect
scenario. This is screaming for the unanticipated circumstance. Yep, you got it. So in that case, we know that after contract formation, there is an unanticipated circumstance. And, I don't know what unanticipated means. I don't know what's unanticipated, right? It sounds to me like unanticipated means just you didn't expect it to happen. Not that you couldn't have envisioned it. You can envision anything. I can envision that it would have gotten cold if I thought enough about it. But I think the way to think about unanticipated is just as it says, you didn't expect it. You didn't anticipate it. I didn't expect this to happen. So something happens that you don't expect to happen. And you then go and ask for a modification. It's cold out. The fishermen go and say, look, boss, we're freezing out there. Can we get more money? And, you don't have to, you don't have to coerce. The restatement says you actually can threaten to not perform. And that does not necessarily mean you can't use this doctrine. Facts are surely going to matter. It has to probably be something where you are, well, I shouldn't say that, the restatement says you can't coerce, but that doesn't mean that you can't threaten to breach. So the dividing line is between if they think you're being coercive, then that's bad. But if you're freezing and you're threatening, like, I can't work in these conditions. I'm freezing. I'm not going to work. That doesn't sound coercive, right? That just sounds like it is the situation that it's justified. Let's say that you wouldn't want to continue. You feel like you can't continue working in those situations. Coercion is still bad under the unanticipated circumstances, but threatening to breach is not necessarily coercive. So you go and you say, look, I'm freezing. We can't do this, or maybe you don't say that. Let's just keep the facts simple. I don't threaten to not continue. I'm freezing. Will you give me more money? Assuming it, and I'm going to give you the elements of this doctrine. So there's only three. First, the promise modifying the contract. And you're going to say yes. You're going to say, yes, I'll give you more money. We go back to work. I do the work. I finish the season, and then you don't pay me the extra money. And I sue you for the extra money. And you say, hey, there's no consideration. And you would be right, assuming that you haven't been discharged under another doctrine down the road that we talk about impracticability. That would change everything, because then you wouldn't be under a duty to continue performing. Let's forget about that. Let's assume that it was cold. It wasn't so cold that your duty was discharged. You still were under a pre-existing duty to fish, even though it was really cold. The promise modifying it, the extra money, had to be made before the contract was fully performed on either side. So it's got to be what we call executory, meaning that neither party is done. This doctrine is about modifications of a transaction midstream, no pun intended, right in the middle. As the parties are in the middle of this transaction, something happens. And number two, the underlying circumstances that prompted the modification were unanticipated by the parties. Again, to me, that just means we didn't expect this to happen. It doesn't mean we couldn't have foreseen it. We may have been able to foresee it, but we didn't expect it to happen. And number three, the modification has to be fair and equitable. So if the court believes I'm trying to coerce you, they're going to say, going overboard, like I'm not working, it's cold, and I can still work. And I'm like, yeah, but we're not working. That probably sounds coercive. If it's really cold and it's understandable, I wouldn't continue working. Probably not coercive. If I never threatened to breach, not coercive. And it's got to be also what's the modification itself has to be fair and equitable, meaning that I really need to be getting whatever the additional stuff is I'm getting, it needs to be generally proportionate to the circumstance that's happening. So if it's cold and I'm threatening to not perform unless I get 20 times the amount of money, that sounds like that's not proportional, because we want to think that the parties are making this modification because of the unanticipated circumstance and to account for it and to give something extra because of it. Anytime the court starts thinking that one party's going overboard, they're going to start thinking, well, this doesn't sound fair and equitable. This sounds more like we're dealing with coercion. This doctrine is not about coercion. This is about the Blumenthal's assuming that the difficulty of her business is unanticipated. So it makes it a little bit harder case. But yes, that situation, the doctrine would apply, the doctrine you gave, the hypo you gave, the fishermen, the cold weather, they're not trying to coerce. They are in fact seeking the modification because of the cold weather. Assume it's midstream of the transaction, and let's assume the amount of money that they're asking for and that they get is something that we think seems a fair and equitable amount. That promise to modify is now legally binding. And if Alaska Packers doesn't pay it at the end of the contract or before, they are in breach because that promise is legally binding.
Now, Dan, this might be the segue to contracts for the sale of goods, but your description of unanticipated circumstances, that doctrine, is really making me think that that's the common law translation of the good faith requirement.
Okay, so let's talk about it. And I'm going to give one caveat because I've done this long enough that I know what students might be thinking about the unanticipated circumstances doctrine. And before we wave goodbye to it, or at least talk about the difference between that and Article 2, students need to recognize that the unanticipated circumstances does not mean there is consideration for the modification. It does mean that the promise to modify is legally binding, but it's what we would call a consideration substitute, just like promissory estoppel is a consideration substitute. It used to be that the phrase consideration was used very broadly to describe any situation, any rule that would make a promise legally binding. Now, second restatement business, and actually I think this even started with the first restatement, started peeling away from consideration anything that was not a bargain for exchange of things of legal value. It didn't mean those other things were no longer making promises legally binding. But what it did mean is that they weren't under the consideration umbrella. They were their own separate doctrines. And the reason why I say this is it's an easy multiple choice wrong answer to write. I'm writing an unanticipated circumstances question. And Steve, I know students look at me having to have 3 wrong answer choices, and they feel bad for me. They're like, oh, professor,
It is such a
hard
burden.
life.
Yeah.
You got to come with 3 wrong answers. We feel for you. The struggle you must have. I'm like, oh, finally you understand me. Yeah.
I am going to second that sympathy, that heartfelt sympathy, and say that it is harder to write distractors than it is right answers.
It is. It is. Thank you, Steve. I appreciate it. Thank you.
But it's not fair because you've looked at so many essays over the years that you know what students' mistakes are, so you can make them extra tempting.
I can indeed. And I could do things like I remember I gave an exam once. I think it was employment law. I think you may have been in that class actually, where I remember a student, I really struggled with wrong answers. And the student came, he's like, yeah, so like basically B was dead fish, C was really dead fish, and D was, yeah, really, really dead fish, because they were like so obviously wrong. And I don't do that in contrast. So what I will do in contrast, to have a distractor on unanticipated circumstances, I may say the unanticipated circumstances provided consideration for the modification, which is wrong, because that doctrine does not provide consideration. It is a consideration substitute. And again, students may boo, so tricky. Well, number one, I got to have distractors, but also isn't this part of becoming a lawyer, which is we are so precise with our terminology and just getting you used to using words precisely.
Millions, billions of dollars are won or lost based on a word, a single word, sometimes a comma. I mean, for God's sake, you got to get precise. This is the name of the game.
Exactly. So don't blame me. This is tough love. I'm just getting you ready for the practice of law. Contracts for the sale of goods, Article 2. Well, you knew, Steve, you knew Article 2 was going to go soft on things. Come on, it's Article 2.
It's all those bleeding hearts. Those those restaters are very, very soft. They're always trying to get around these harsh rules.
They are, and this is it. So here is, if you're taking a contracts class, it is not heavy on Article 2. There's still a good chance that you're going to get a couple Article 2 distinctions, and this is probably one that you would see. Article 2 says a promise to modify a contract needs no consideration to be binding. And then you say, oh my gosh, does that mean that any promise to modify is automatically legally binding? Well, if you peek down at the comments, and let me tell you something, particularly if you're in a commercial law class or a sales class, boy, the comments are where the action is at. The Article 2 comments are quite good, and they're packed with information. Oftentimes, what you think is additional information. The comments note that the good faith requirement, the implied covenant of good faith and fair dealing, runs throughout everything. So it lets you know that although the Blackletter rule up top in the code says you don't need consideration, you might think that every promise to modify a contract, if it is a contract for it's a transaction goods, wouldn't necessarily mean that they're all binding. But they're not. We have a little restriction, and maybe it's not a little limitation, it might be kind of big. There is a requirement that the party obtaining the modification, that sought the modification, have been acting in good faith in extracting that modification. So now what it's done is, it's now done a clear break. The Alaska Packers business, Article 2 still frowns upon, the so-called hold-up game. That's bad faith to try to coerce a modification by threatening not to perform a pre-existing duty under the contract, because you know the other side has relied, they're in a tough position now, and you know they're going to have to agree to the modification because they can't get somebody else to do it on short notice. That's still out. That is not an effective modification under Article 2. But as long as you're not doing that, as long as you're coming in good faith, something happened, or, hey, our price rose a bit. In general, as long as the court concludes you were acting in good faith, that modification is going to be legally binding. Now, this is a little interesting because if I recall correct, I can't remember if it was a court or the comments, say something about, well, typically that means you have to have a legitimate reason to get it. And it is true that Article 1 of the UCC defines good faith, and the revised Article 1, for whether it's merchant or not, also has an objective standard, not just a subjective good faith standard, but good faith includes is it objectively good faith? But as long as there seems to be like a decent reason why you're asking for the modification, the court is likely to say that's good faith and the modification is binding. Now to your question, how does these look like identical twins. I'm looking at Article 2's rule and I'm looking at the unanticipated circumstances doctrine. Are these identical twins? They look the same. Well, this is the way I like to think about it. I think there's maybe a sliver of daylight between the two of these. I think. So it seems to me that hear me out, Steve. You tell me what you think.
I'm skeptical.
I understand. it's going to be a hard sell. It's possible that there could be a case in which an event occurs that was anticipated. We anticipated the price would go up, but we come to you and we ask for a modification, and the court might say we're acting in good faith, even though it was anticipated. Oh, gee, Steve, I know we thought this would happen, but I gotta tell you, now that it has, oh boy, I could really use some help. I know, Steve, I know we knew it happened, but I'm not trying to coerce you. It's not the hold-up game. It's just like, yeah, I anticipated this, but now I'm feeling bad about it. And the court might say, if you promised me that I was acting in good faith, whereas I wouldn't lose on the unanticipated circumstances of the common law because I anticipated it. I will now hang up and listen to the answer. Thank you very much for taking my call. I'll hang up and listen to your answer.
I think you've nailed it. I mean, it's hard to get around that unanticipated. But I think it's certainly the common law's answer to the good faith standard, that it is a way of eliminating the coerciveness. They just chose to use the unanticipated aspect of it. And I think that is the real bottom line distinction between the two, because I think that's absolutely right, because, Mrs. Blumenthal, would still say, total good faith, if the UCC standard, if the Article 2 standard had been there, truly good faith, she doesn't have the money, she can't pay. Why don't we allow this modification? But I think you do. I mean, I don't see how you get around that, having to establish that it was unanticipated. Maybe it was depression, record. I mean, that she could probably do if that were the cause. And in fact, interestingly, did that come up at all in the case?
I think there was. So it was during the Depression, is what many people may not realize. Steve, you probably do, you're an econ major, right? And in my understanding, I'm not an econ professor, is that the Depression got worse as it went, right? The banks started failing, the stock market crashes in 29, and through the early 30s, right? Things got worse and worse. Of course, it wasn't, I believe it was World War II that got us out of it. We got the New Deal with Roosevelt. And so things were getting worse. And so, it's interesting, if she started her shop, let's say in 1930, after the stock market crash, and things are getting worse, they might anticipate that things are getting worse. And so it might be hard for her to argue that if she didn't anticipate things getting worse, she may have been hoping, and then things do get worse. And they did talk about that, I think, a little bit, but they didn't have to talk about, they certainly didn't talk about it in terms of should let her out or not, because this was the unanticipated circumstances doctrine, I think, is a newer I think it's probably been influenced probably in large part by Article 2. A lot of the common law has been influenced by Article 2. Article 2 is more recent, so you think it's the common law influences Article 2, but Article 2 has had a lot of influence on the common law after that. And if I recall in Levine versus Blumenthal, it was just like there's no consideration, you're done. They weren't even talking about an unanticipated circumstances doctrine. And I think that the lesson for the students here is maybe not so much to worry so much about what the difference is and is there a sliver of light, but you've got to speak the language of the rule. So if it's Article 2, right, they shouldn't be talking about the, and I say on the bar exam, if Article 2 is a source of law, they should be talking about good faith requirement. And if it's a common law, they should be using the language of unanticipated circumstances, even if there's really not a big difference here. They need to be using the right language, because I would think they're probably going to get dinged if they're using the wrong test, the language of it, even if the tests are really almost the same.
I think that's right. And the bar is a little bit more general, but this is worth mentioning, where if there is a modification, and you do have to identify at the beginning of your essay, you're going to talk about UCC versus common law and settle that at the beginning of the essay. And then when you get down to the consideration question, that's when you talk about that difference. But if there's a modification under the UCC, I think good faith has to appear. If it's common law, I think you have to say consideration. You don't really have to say unanticipated circumstances on the bar exam, because they don't get that far down. So you're kind of in luck at the end of your third year.
That makes sense. So, right. So your thought is for bar exam, the big divide is not this, what we did, the discussion we just had. So that to me is unanticipated versus conversationally good versus good faith. It is consideration versus no consideration, just good faith.
Yep, exactly.
So that's good news. So if you're a 1 hour listening to this, right, hold on, right? Good news coming for you in a couple of years. So the last one is the settlement of an invalid legal claim. So there's really only 2 situations in which there's not going to be legal value. One is when there is a pre-existing legal duty and you're repromising. Oh, and I should know that because this sort of relates to the settlement of an invalid legal claim, if there is any doubt, genuine dispute, or reasonable person believe it's in dispute whether you have a legal duty, then it has legal value and there is consideration. So it's only when it is clear that you have a legal duty, there's no dispute about it. So the settlement of an invalid legal claim is when a party promises to release a claim. So I say, hey, Steve, I promise not to sue you for X, or I'll release my claim I have against you. Maybe I allege that you ran over my bike, and I say, hey, Steve, if you promise to pay me $100, I promise to release my claim against you for running over my bike, and I promise not to sue you. These are technically distinct things. One is a promise not to sue. The other one is a release. But let's not worry about that. The distinction is not terribly significant. In either event, I'm basically agreeing not to assert a claim against you. And you promise me the money. And then you decide not to pay it. And the question is, was your promise to pay me the money for my release legally binding? And the question is there consideration? Now, there's no doubt there's a bargain for exchange. Each party is motivated to get what the other is giving. You're motivated to get me to release and not to sue, and I am motivated to get you to pay me the money. The question is going to be, is there legal value? Obviously, there's legal value for the money. You're promising to pay me money. You had a legal right not to pay me any money. You're not under any duty to pay me this much of your money. And so that has consideration. The question is going to be is, and you say, well, do you have a legal duty to compensate me? Yeah, the claim's not been gone to judgment or anything like that. We wouldn't think of it like, oh, maybe you do have a legal duty to pay me the money because you ran over my bike. That's overcomplicating it. We wouldn't think along those grounds. We say it's your money. Yeah, until the court tells you to pay it, you're not required to pay it. And so you're agreeing to relinquish ownership of that money when you currently don't have to. So, because certainly promising to pay it early. And let's not get into would you owe interest? See, I complicated I don't mean to with these digressions.
It's talent.
It's a talent. It's a talent, you said?
Yeah, absolutely it is.
That's my talent. What's your talent? Digression. Well, that's good. That's awesome. That's a talent I want. He's good at digressing. The real question is there legal value coming from me to you? When I release a claim or I promise not to sue you, is that a legal benefit to you or is it a legal detriment to me? Do not talk about actual benefit or actual detriment. This will get you in trouble. Because what's going to happen is that if you do actual benefit, actual detriment, you say, well, it's an actual benefit to you to not have me sue you. And it's a detriment to me to not, get to sue you and get recovery. But again, we don't ask actual benefit, actual detriment. We ask legal value, legal benefit, legal detriment. So here's the rule. So we talked about the pre-existing duty rule. I'm like, well, why do we have it? Well, why are courts? And we said, well, we generally have a pre-existing duty rule because courts are kind of concerned that when somebody's repromising or promising to perform a legal duty, that's strange. Why are they getting extra money for simply promising to perform a legal duty? Something weird is going on, and we're concerned that there may be some coercion here, threatening not performing legal duty just to extract more money. So now the question is, why does the law take a special interest in the settlement of a legal claim and where there's legal value? Well, the concern is threatening frivolous claims. When I say, look, you need to pay me $100, or I'm going to sue you for running over the bike. You say, wait, what? When did I run over your bike? Yesterday. And you're like, okay, I was out of town. I was on a vacation. I wasn't even here. I'm like, yeah, well, you can prove it to the jury. I'm going to sue you anyway. I basically know you didn't do it, and I'm just threatening to sue you to extort money. I'm basically extortion. It's basically Alaska Packers kind of business. Let's extort money out of you. I'm going to sue you. That's what we're concerned about. What we're not concerned about is settling valid claims or even claims that turn out to be invalid. But I'm not acting like a bad guy. I think you ran over my bike. You say you're out of town, but somebody saw you and said, "Oh, Steve did it," and I think you're lying. You don't have any evidence you were out of town, and I think you did it. We don't know if you know if you did or not, but I don't know if you did or not. And I'm not trying. I'm not being a bad guy trying to sue you. We want to encourage settlement of lawsuits. It reduces the time everyone spends litigating, the parties, the court system. We encourage it. We encourage settlement. Let's do it. If parties can resolve their differences without going to court, this is great.
And can I jump in and say that it's like waiving a legal right? I have the right to sue you if there is a bona fide dispute and we can have it out in court. So it almost is the same as waiving a legal right. Settling an invalid legal claim is not. If it's totally on its face that this is just a shakedown, then that's not really waiving a legal right. You don't have a legal right to file frivolous lawsuits.
I think that is a perfect way to think about it. And it is interesting that the restatement doesn't talk about it in that way. And I always wondered, is that because maybe there's a little bit of a difference, say, between Rule 11, which if you're 1L watching this, there's a good chance if you haven't yet, you will come across Rule 11 in your federal civil procedure class, which is you can't file frivolous lawsuits. And I always wondered, is there maybe a little bit of daylight between these two concepts that it could be a frivolous claim, but I also bring it in good faith. I think, I'm not very smart, and I think you did it, but it's frivolous, but I'm still not a bad guy. So, but I think you're right. I mean, I think that even though it isn't talked about in those terms, I think that is the way to wrap your brain around this. From a practical aspect and a more simple aspect, that is what's going on. It's very much akin to what we just talked about with the pre-existing duty rule. And so the way we're going to balance this, so we have these competing interests. We don't want people threatening frivolous lawsuits and extorting money, but we also want to encourage settling legal claims. And so how is the court going to reconcile this? This is what they're going to do. the court is going to say that obviously if you settle a valid claim, there's consideration. This is not the big question. It was a valid claim, settle it, we're all done, it's settled, there's legal value both ways. Settlement agreement is legally binding. Where things get interesting is when a person settles an invalid claim. And should there be consideration for that one? Well, if you settle an invalid claim, as what the restatement says is that as long as the party asserting the claim believed that their claim had potential to succeed, or a reasonable person, it's an or a reasonable person would believe it had a chance of success, there is consideration, it has legal value. The waiver has legal value. It's a broad test because the reasonable person doesn't have to believe it under the restatement rule, as long as the person was essentially acting in good faith. They believed it had a shot, it has consideration. So I guess in some respects, the person who doesn't know a lot, like, oh yeah, I think this is a good claim. Like, and the reasonable person is like, really? That's a terrible claim. It has no chance. Really? I thought it was a good had a shot. That has legal value, and that settlement will be upheld. The party promising the money in exchange for that release, that's legally binding. They got to pay. Some courts have it as an and. I should teach a case where it's an and. One of the times I teach a case that is inconsistent with their statement, it's an and. So check your jurisdiction, check your professor. But typically it goes hand in hand. If a reasonable person would believe it, the person probably believed it, and vice versa. So typically, as long as it looks like it's got a shot, even though it turns out it was a loser, if at the time of entering into the settlement agreement, it looked like it at least had a chance, wasn't totally frivolous, then it has legal value, the release or the promise not to sue. Only when at the time of entering into the settlement, it's clear to the person, to the reasonable person, that yeah, it's a zero. Now we're thinking, this is just coercion. This is just extortion. Would it not have legal value? And Steve, I'm going to give you, to wrap this up, they'll remind me to talk about something called the rule of folks v. Beer, because I know we've gone long on this, but I can't talk about these subject legal value. I'm talking about the rule of folks v. Beer. But let me just give you the greatest case of all time on settlement of an invalid claim. A woman has sex with a man. She is unmarried. I think he's unmarried too. I think it's like the 50s. So, having
Scandalous.
It is happened in a car. I don't know if that makes it more scandalous or not. In a car after movies, dinner and a movie. And she gets pregnant. And she tells the guy is freaking out. The guy, he tells his dad, but he doesn't want his mom to know. Do with that what you
break her heart. It's just break her heart.
Decide for yourself, right? Is like, why is he okay telling dad? Like, yeah, I can tell dad, but I can't tell mom. It's a case called Feig versus Bowen out of Maryland. And he's freaking out because he doesn't want mom to know. She's threatening to file paternity proceedings against him. And they enter into which she has a right to do. I think she was threatening. I mean, it's clear that was in the offer. And they enter into a settlement agreement. Steve, you are going to love this case. You don't know, you're going to love this case. He promises to pay her medical expenses, I think maybe her lost wages for a period of time, and to pay child support. So they enter into this deal. He pays for a while, like a year and a half. I always figured after a year and a half, he looks at the kid, and what does he say? What does he get suspicious of? This kid's a year and a half now.
The kid's got curly hair.
Exactly right. And he doesn't, and the mom doesn't. But his buddy Jim does. Hey, that looks like my buddy Jim. So we don't know that that's what happened. I just all speculated.
Yeah.
So he thinks it's not his kid. So he stops paying child support under the contract. I don't know why, and he also goes and gets a DNA test. And the doctor says, you're not the father. The woman then sues paternity proceedings against him because all bets are off. He stopped paying the money. He's repudiated the contract. So she's like, well, you're repudiating the contract. All bets are off. I'm suing you for paternity. Well, he wins. She loses, and he's not the dad because the doctor is going to come in and say, yeah, he's not the dad. So she then sues him for breach of contract. And the court says, you are in breach. You must honor your contract. And I think that the child support payments were going to end because I think she put the child up for adoption. He got lucky on that one because I think he promised to pay till the kid was 18. So the damages could have been a lot worse. And the court says, you had a contract. And he's like, are you kidding me? That's not my kid. And the court says, yeah, we get that. We understand. I was there. We saw the record. But the question isn't, this is not family law court. The question is not whether you are the father. The question is whether or not you made a promise to pay. And was your promise supported by consideration? Because if it was, you're out of luck. Your promise is legally binding. And he said, wait. I didn't get, what did I get out of this? Where's the legal value? I didn't get any legal value out of this. It's not my kid. She waived a legal claim against me, the paternity proceedings, but we now know she waived an invalid claim. And what I love about this case is in the 99.9% of the settlements, you never learn if the plaintiff's claim was valid or invalid, right? I mean, we settle up and it never goes to a jury to decide if you were negligent, right? When you didn't clean the wet floor up quickly. We just never know, right? I mean, it remain a mystery as to whether your claim was valid or not. We just never know.
I think that's better sometimes.
Well, it probably is. I mean, that's why you said, parties would be unhappy. When you find out, someone's going to get unhappy. That's what happened here, right? Is that because we actually found out that it was an invalid claim, he's very unhappy and he doesn't want to pay. He stopped before. Once he finds out it's invalid, that he's not the father, he starts paying. And so I think it is nice because we'll never know. Did you pay too much for that settlement? We'll never know. Did you take? No one's bitter. Well, actually, they're always bitter after settlements, aren't they? Everyone's always bitter. A good settlement is both sides are a little unhappy. But, I think it is better not to know. But here he knew. And so what the court says is, look, we got to decide whether or not there's legal value. So the question is this is a settlement? There's no doubt it's an invalid claim. But deciding whether or not there is consideration is assessed at the time of contract formation, not after. We all know this turned out to be a bad deal. As the court snickers, right? This is a horrible deal for you, awful. And because but that's not the question. The question is, was there consideration at the time of contract formation? And at the time of contract formation, did the woman believe, and this court did an and would a reasonable person have believed she might have had a valid legal claim? Well, the answer to that was yes. Clearly, he was a suspect. He's not going to pay the money unless he's a suspect. He can deny having sex with her, but how far is that going? He clearly had sex with her around the time that she was in fact impregnated. And so it's like, who shot JR? He's up there, isn't he? And so if you're up there and if you are a person of interest, I don't know, at least he's more than a person of interest. He's a suspect. And so her claim, she believed, and according to that alone would have been enough for her statement, a reasonable person would have believed at the time that her claim might be valid against him. That's all you need. The fact that you made a bad deal in retrospect doesn't matter. So boom, legal value.
And, she could have had a couple more contracts under those facts. She really missed an opportunity there. And the other thing I'm thinking, I wonder if mom found out once it was all done. Like if mom ever got wind of this atrocious.
She was,
Yeah.
I'm not the father. That's got to mean something. I see her holding a newspaper and like
Yeah,
whacking him on the head. And he's
yes.
like, what? It could have been worse. It could have been worse.
Or a purse or something,
Yes.
hitting him with a
He's
purse.
running around. Dad's laughing in the corner.
Right.
Could have been worse. One final rule to talk about. Oh, Steve, this is a horrible, horrible rule. I saved it for last. I'm sorry. It's so horrible. It's got, you can't do it at the outset. It'll dampen everyone's mood. Steve, you owe me $500, let's say. You, sir, are a debtor, and I am your creditor. And the $500 is what we'd say is mature, meaning it is due and past due. The amount you owe me is not in dispute. We would say the amount is liquidated, meaning there's no dispute about the amount you owe me. You owe it. You owe me 500. Everyone knows it. You owe me 500 is overdue. You come to me, or I come to you. It doesn't matter. And we agree that I will accept $300 and forgive $200. We agree that if you pay me now $300, because maybe you're having a hard time getting the 500. If you give me the 300 now, I will forgive the remaining $200 balance. And we reach that deal, and you hand me the money, and I cash the check. Yes, I've accepted your offer because I have exercised dominion, obviously. I mean, you could send me the check. Here's 300, settlement in full, and I cash the check. I've accepted, I've exercised dominion over it. It's fine. I guess there's an offer, there's an acceptance, but is there consideration? Steve, there's no consideration there because you've given me the $300. You were simply performing a pre-existing legal duty. If you owe me 500, you owe me 300. If you owe me 300, you don't owe me 500, but if you owe me 500, you owe me 300. You owe me 300 plus. So when you gave me the 300, you were simply performing a pre-existing legal duty. And what that means is there's no consideration for that agreement. It does not matter that I exercise dominion over your funds. That's just acceptance. In these modifications, there's almost always mutual assent on both sides. Alaska Packers, that doesn't mean that there's consideration for the modification. And I can turn around and sue you with a $200 balance because it was not discharged, because our agreement to modify was not legally binding. And the problem is I don't see a lot of other doctrines to save you on this list. Promissory estoppel, I mean, where's the injustice? I mean, there's not a lot of injustice. I mean, you owe me the $200. I don't see a lot of promissory estoppel being able to be used here. There's no unanticipated circumstances. I mean, is it unanticipated you're having difficulty paying me back the money? No, I don't think so. I mean, I guess if we're talking, if it's a contract for sale of goods, but here we're talking about like a loan and you owe me money and stuff like that. We're talking common law. So this is a rule, people don't need to know this name. I mean, no one's going to touch on this. It's called Folks v. Beer for an old English case that held this. But so this is a very nasty doctrine. And this came up, it would come up with things like mortgage modifications. If it's all one way to take less money or the bank to take it on a longer period of time to pay it back, watch out. There's no consideration. Now, like you had said with Blumenthal, if it's not due yet and you're paying it early, well, now there would be consideration to forgive the remaining $200. Or you're doing something extra. I'll give you $300 plus my old bike. Okay, now we're talking because we've got something in addition to what you had a legal duty to pay me. But without that, there's no consideration for it, and you still owe me the money. Are you speechless? That's horrible. You can't even, you're speechless. That's so horrible.
But I know a wise man once said there's no crying in contracts, so I'm just going to choke it back.
Thank you. Yes, indeed. There is no crying in contracts. And so, yeah, what you have to know is don't shed a lot of tears on your contract exam for parties, because a lot of times that'll mean that you're getting the wrong answer. Don't say, oh, that's got to be forgiven because it's so horrible. Yeah. Sometimes we have really harsh rules, and that is just the way contract law is at times. Okay, that is it for lesson number 10, legal value. That completes the discussion of consideration. Hope you enjoyed it. We will see you next time on K Talk.